Hey, welcome everybody. Welcome to today's episode of Law Self-Defense. We are, of course, covering the continuing sentencing of former police officer Aaron Dean, who was convicted last week of improperly convicted last week of reckless manslaughter in the death of Atatiana Jefferson. The court is actually in session right now. The jury's not been brought in yet, but the defense is complaining about the Dean family when they were escorted out of the courthouse last week after testifying in favor of their son during sentencing, was apparently accosted by a mob. So let me pull up what's happening in court at the moment, and we'll catch up. Here we go.
Same tone and nature that was going on the streets outside the Justice Center at the time. As we went on to the next day, Friday, when we were here last in court, initially, the state was gracious enough to provide us an image of Mr. Mata from the Tarrant County Sheriff's Department system. Mr. Mata has a series of pending cases. He's also a convicted felon. He has assaulted cases in his past, and the undercover plainclothes officers were not able to do a positive identification based on the last mugshot that we had in the system. It wasn't until Mr. Mata made his appearance here in your actual courtroom that the plainclothes officers were able to positively identify Mr. Mata as being one of the same that did a bull rush toward one of their vehicles and was creating the overtones of the terroristic threat. This court's well aware during the history of this building that we have metal detectors, other objects that can cause people serious bodily injury have been brought into this building surreptitiously. My law partner, Bob Gilman, he was a prosecutor, was attacked with a knife made out of a glass shank during Capitol voir dire at one point. Metal detectors only do certain things. Mr. Mata sat within the 21-foot rule of the Dean family in the courtroom. As the state's expert, Mr. Priest, talked about 21 feet, probably should be 35 at this point. He had on multiple layers of clothing. We could not identify if he had anything on him. The same people he was threatening to cause harm to the day before, he's now within arm's reach up in the courtroom. The defense's contention all along is this case should have been moved out of town for publicity and the security risks that were going to go on. The defense asked to have Mr. Mata sworn in and others sworn in at the time last week to make a bill of exception to our continued issue of the change of venue. We were going to do that with Mr. Mata at a break. That's why we asked to have him sworn in. Mr. Mata refused to take the oath, and everybody else got to see what happens when you choose not to take the oath at that point and are disrespectful to a court that's in session. So for those reasons, that's why we asked to have Mr. Mata sworn in without revealing all the sources and methods of the undercover peace officers that are assisting in this case. We felt that the terroristic threat event that took place on Thursday warranted him being sworn in to be put as part of a proffer for our bill of exception as to why the change of venue had not been granted.
The court had received information from security as to their concerns as to Mr. Mata. And additionally, the state had furnished to the court a list of his convictions, his pending cases. There are multiple convictions for assault. There are 4 pending cases for interference with public duties. And when I saw him come into the courtroom and sit within the immediate reach of the Dean family, it caused me some concern. But that is over. My goal is to do a fair trial and to make everybody feel safe in this courtroom. And
if I could add, Judge, without revealing our sources and methods, Mr. Mata is quoted in the hallway, "I shouldn't be here today. I know I'm going to be arrested." And that was on Friday, indicating, I guess, events previous, which I can only think would be the terroristic threat crime that he committed. Not only in the presence of those plainclothes, uniformed sheriff's department, and Tarrant County Criminal District Attorney employees that can witness and know what a violation of the law is when they see it.
well, as I said previously, my goal is to protect everyone. In fact, when all this was happening, I looked up and the state was over in the well of the jury box, away from their tables. And I felt what I needed to do at the time to protect everyone for courtroom security. Mr. Mata's bonds will be reinstated today. So we can move on. Mr. Smith, does the state have anything you need to place in the record?
Nothing from the state, Your Honor.
All right. Are both sides ready for the jury?
State's ready.
Okay, let's go.
All right, so the jury is going to be brought back in. Of course, for those who don't know, I am attorney Andrew Branker for Law Self-Defense. And this is the ongoing sentencing of former Fort Worth police officer Aaron Dean, wrongly convicted last week of the reckless manslaughter of Atatiana Jefferson in a trial that's just been a train wreck of a misstatement of law, facts, claims not in evidence, and a very, very weak defense team that's allowed their client to be railroaded into prison. So a tragic event, the death of Atatiana Jefferson, but zero evidence of criminal conduct here on the legal merits. A conviction that can only be characterized as a gross miscarriage of justice. And I lay the blame largely at the feet of the defense team. I mean, the prosecution knows what it's doing, of course, and that's terrible. But there's a reason you have defense counsel.
Members of the jury, the defendant Aaron York Dean has been found guilty by you of the offense of manslaughter. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. The punishment for the offense of manslaughter is by confinement in the Texas Department of Criminal Justice for any term of not more than 20 years or less than 2 years. In addition, a fine not to exceed $10,000 may be imposed. You are instructed that in determining the defendant's punishment, you may take into consideration all of the facts shown by the evidence admitted before you in the full trial of this case and the law as submitted to you in this charge. In this case, the defendant has filed before trial his sworn motion in which he requests that if he is convicted, he be placed on community supervision. If you find that the defendant has not ever been convicted of a felony in this or any other state, and you assess the punishment of the defendant at confinement for a term of not more than 10 years, and you recommend that he be placed on community supervision, then let your verdict show the punishment which you assess, and further show that you recommend that his sentence be suspended and that he be placed on community supervision. If you recommend that the defendant be placed on community supervision, the judge shall determine the conditions of community supervision and may, at any time during the period of community supervision, alter or modify the conditions. The judge may impose any reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. However, if you do recommend community supervision, the court is required by law to follow the jury's recommendations. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege according to the defendant, and in the event he does not
hit
testify,
that like button.
that
If you want
fact
the
cannot
YouTube
be
stream to
taken as a
continue,
circumstance
we
against
need
him.
more than 25% likes.
In this portion of the case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Your verdict must be by a unanimous vote of all members of the jury. In deliberating on this case, you shall consider this charge as a whole, and you must not refer or discuss any matters not in evidence before you. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved of the credibility of the witnesses and the weight to be given to the testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed these instructions as judge. The last 2 pages of the instruction contain the respective verdict forms. The first verdict form says community supervision not recommended. We, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment of confinement in the Texas Department of Criminal Justice for, and there is a blank, for the presiding jurors to fill in the number of years that the jury agrees to. In addition, we do or we do not, and the presiding juror will circle that phrase, assess a fine in the amount of blank. So if you assess a fine, circle we do assess a fine. If you don't assess a fine, circle that. We do not recommend community supervision. And there's a space for the presiding juror to sign on that form. The second verdict form is on the last page, and it recommends community supervision. So in that situation, the presiding juror will fill in the number of years that you assess between 2 and 10. There, again, you can assess a fine or don't have to assess a fine. If you do assess a fine and you're recommending community supervision, there's a third blank for the presiding juror to certify whether you want the fine that you assessed be paid or that it be suspended and placed on probation. Ms. Diener. I need the lights, Brian.
May it please the court.
Yes, ma'am.
Atatiana's family, they received their life sentence on October the 12th of 2019. They received their life sentence without her. They'll never get her back. As we approach the Christmas holiday and the end of this year, we think about those that we love. We grieve for those that we've lost. And for them, that sadness, the grief. There's multiple stages when you go through the loss of someone close to you. For those of us that have gone through that, we know what that's like. A few years can pass, and yet it feels like just yesterday that they were here. You heard Adarius testify. You heard Ashley testify. For Ashley, for Amber, for Adarius, for Zion, their whole lifetime will be without her. There's a part of grief that we all suffer when we get to a certain point. When we think about that person, there's a realization for us all. It's the finality of it. Right? In your heart, you miss them, you love them, and then you really realize they're never coming back. And that's the hardest part. And that's worth something. And in this case, it is worth something. Her life
It's worth something.
is
And in this
worth
case, it's worth something.
so much more than a probation sentence. So much more. This family, her memory, her legacy, this community deserves more. In punishment, we brought you multiple witnesses, and those were witnesses we were not able to bring you in the guilt innocence portion. You heard from Dr. Kyle Clayton, the forensic psychologist, and this is an expert that both sides call. He testifies and works for the defense, he testifies and works for the state. Whoever calls him, he does good work, and he testifies to whatever he finds. He was hired by the Fort Worth Police Department, as he's been with many other agencies, to do a pre-employment psychological evaluation. Narcissistic, grandiosity, has grandiose tendencies, domineering, over-controlling, forceful, dominant personality traits, uncritical of himself, denies flaws, minimizes behavior, little tolerance for disagreement, can be aggressive, has an unrealistic view of himself, someone that thinks that he can fly all of us in a commercial airline despite never having an hour of training. Someone that when you're asked to rank yourself, 9 out of 10. Not suitable for a position as a police officer. Psychologically speaking, he is not suitable because these tendencies that are well formed, ingrained, a thread throughout his entire personality, these are unchanged traits that put himself and others at risk. It is like a roadmap back in 2017 to how we ended up here and how we lost Atatiana back in October of 2019. These things don't change. And how do you know that even in the 3 years between the time that that was done and today? Because last week, the defendant testified. I think they did a pretty good job out there. You shot a woman in her own home. You disregarded every single standard operating procedural, general order, and just
That's a
pure,
lie.
reasonable human instinct. And a 28-year-old woman died, and you give yourself a fine job. You give yourself a B. This is not somebody that thinks he has done anything wrong.
Anyone who's ever been divorced recognizes this woman.
When the defense counsel gets up here, they're going to talk about the witnesses that they called. And those witnesses are not witnesses that you could hear from until now, till punishment. You heard from us, Dr. Clayton. You heard from us, Adarius Carr. You heard from us, Liz Turner. And why is Liz Turner important? Because we wanted to show you everything that we knew about him. And it's important to know, going all the way back to college, that's the way that he treats people. He's entitled, he's arrogant, he's aggressive. And that was 20 years ago, and she was talking to you from a place going right back there. She remembers that. She got emotional. It was hard for her.
She saved her 5-page complaint for
because that's
20
who
years.
he is.
Give you 7 minutes, Ms. Steve.
Thank you. So when he gets up here, when the defense counsel gets up here and talks to you about why you should give him probation, because that's what they're going to do. They're going to get up here in a minute and they're going to ask you for a very low sentence or probation. They're going to ask you for mercy. Mercy's been shown already for this defendant when your verdict was returned for manslaughter. Mercy is earned. It is not just given. And I want you to listen to why they're asking you for a low sentence or probation. Because his family got up here and said he was a good guy? Every case that I prosecute, there's a family member that gets up there and says they're a good guy. It's part of the deal. But I think it's important to think about the witnesses that we didn't hear from, just as much as the ones that we did, right? Family members. We heard from one field training officer, just one single Fort Worth officer that said, I knew him for about 3 or 4 weeks, didn't have very good personal skills. We kept up. I don't know anything about this case. But don't you know that if the Fort Worth Police Department and all those guys and girls that work for him, 18 months side by side with him, almost 2 years, don't you know if they had something good to say, they would have been in here? There would have been a line out the door.
Bad to say, you didn't call him either.
And don't you know that those 3 psychologists that gave him a passing score, if they had something good to say, if they disagreed with Kyle Clayton, don't you know they'd been in here saying that?
Well, they did
They
disagree.
would.
Man,
Guarantee you they would.
I don't like any of this.
But instead, we have a family, which they're good people. This is not their fault. This is not their fault. But valuing them or him over her is a tragedy. It is not right. It is not just.
Nor is that necklace.
In this case,
But in fairness,
only
this defendant, this
appropriate verdict
convict
is a
now
maximum
is in this
sentence. It's the
position
only
because
thing
his
that's
defense team failed him.
And when the judge talked to you about the court's charge, I want y'all to think about, and y'all don't have copies with you, but you'll be able to go back and read this. When you go to this certain page, I want to ask you, do you feel comfortable with the fact that the judge gets to set the terms of probation? He gets to get off. If he wants to get off early, judge sets the terms. You heard from the probation officer talk about probation and how it is. It is no different than what all of us do every day. That is not enough. That's not even a slap on the wrist. You heard that this defendant has been out on bond for the last 3 years with his family, laughing, doing projects with them, something that they don't get to ever do. They don't get to ever do that. Doing probation values that over them, and that is not okay. The other thing that's talked about in the court's charge is a fine. I can always get questions about the fine. If you want to put an exclamation point on your verdict, then you put a fine. It doesn't go directly to the family. It goes to a fund. So you put a fine as an exclamation point. When you think about this case, you all leave here today. They go home without her. Zion never gets to have Aunt Tay again. It doesn't matter if it's a year from now, 5 years from now, people are going to ask Zion, what happened to Aunt Tay? What happened? What did the jury do? And thankfully now with your verdict, he gets to say that they found him guilty. They're also going to ask another extremely important question. What did they do? What do you want Zion's answer to be?
It's so improper.
The only just verdict is 20 years. Anything less is a travesty of justice.
Mr. Gill?
Wonder if Gil's going to wake up today.
A little late for that.
Morning. Having an entire weekend to think about what remarks I was going to make here this morning is a long time. So I guarantee you I went over this matter in my mind 100 times or more about what I was going to say this morning. I've been up here for 30 seconds now, and I already know it's going to come out in a different way. Your verdict at the first phase of the trial is important to note. It's important to note what was said by the state of Texas, because if you take the emotion out of their remarks, there's really very little left. They want you to base your verdict on emotion. You know, the family's not going to get to see Atatiana anymore. We know that. It's a tragedy. We've acknowledged that. We've talked to you about that. There is no changing that. Your verdict won't change that.
Why does he keep talking about the verdict?
It can't change
Not
that.
very good at his job.
You were talked to at the jury selection phase of this trial about whether or not you could give fair consideration to the idea of probation, to assessing a probation for someone that's been convicted of the offense of manslaughter. And each and every one of you said you could give fair consideration to that concept. And that presupposes that someone's life has been taken. And it presupposes that that person isn't going to be with us anymore, that their family's going to miss them. It presupposes there's been a tragedy overlaid over the facts of the case, which is exactly what we have here. A tragedy that'll never be changed. And the prosecutors were very defensive about the fact that we were going to ask you for probation in this case. That's because they know that that's really what this case is worth. But they want you to do something else. So, look at your verdict at the first phase of the trial. You found that Aaron did not act intentionally. You found that he did not act knowingly. You found that he did not intend for there to be a death resulting from his actions. Your verdict said you felt he acted recklessly, which is a much lower culpable state of mind than intentional or knowing.
So weak. That's why the sentence is 1/5
You
as
know from the
much.
facts of the case that this case was not premeditated. There was no malice involved. There was no forethought involved. Remember the state stressing to you during closing arguments how fast this matter happened? That is a very important fact for you to consider in your deliberations at this phase of the trial. How quickly that decision had to be made. Aaron Dean is literally being judged for a second of his life today. And he's being judged under man's law, not God's law. The talk about eye for an eye, I'm not sure exactly what that was meant to convey to you during questioning of our witnesses, but we're not here about God's law. We're here about man's law. And the man's law is contained in the court's charge that Judge Gallagher gave you.
This is all.
We're not here about money damages. That's for the civil court down the street. And you heard that there's a matter pending down there regarding this. This is about what is a fair and just verdict under the facts of this case and this case alone. What is the fair thing to do here? It's not a weighing or a balancing contest between the Carr family and the Dean family. It's not who's worth more. The judge doesn't tell you that in the court's charge. It's about what is the fair and just thing to do under the facts of this case. On the questionnaire that you filled out before trial, asking you about the three goals of punishment in the criminal justice system. Those three goals are The three purposes of punishment are punishment itself, rehabilitation, and deterrence. Those are the three things that you are to consider as jurors in a case. You are asked which of those is more important to
Or they're
you,
going to get deterrence.
punishment, rehabilitation, or deterrence. And the answers from the group of you vary. But if you are talking about punishment, what is he being punished for? There was a life lost,
Bad lawyer.
tragically. But
Escaping
Aaron
getting
was
punished for you.
working in the line of duty as a police officer, as a law enforcement officer. He didn't take it upon himself to go hunt someone down that had wronged him before, or knowingly place someone in a dangerous situation waiting for him to spring a trap on them. He was trained by the Fort Worth Police Department. He was hired by the Fort Worth Police Department. He was assigned by the Fort Worth Police Department. He was dispatched out there that night in the line of duty. And his testimony to you was that he was protecting himself and his partner. So what are we going to punish him for? Yes, there was a life taken. That's true. But look at how these things happen. Look at the chain of events that set it all up. What is he culpable for? He didn't plan this thing. He didn't set out that night. He didn't get up that morning and go down to the headquarters and get his assignment with anything like this in mind. He was trained in the Fort Worth Police Department Academy to eliminate a threat.
Folks in the comments, Keith Turner is just lying. So take that under advisement.
So keep that in mind, please. Secondly, rehabilitation. What are we going to rehabilitate Aaron from? You've heard by your verdict, he'll never be a police officer again. This situation is never going to repeat itself. He'll have to move on and find some other form of employment, which he's done as best he can. He's probably the person least in need of rehabilitation that's ever sat in a defendant's chair. Because he's a God-fearing, law-abiding citizen of our county. Yeah, Dr. Clayton came in here and said he was narcissistic, and you saw all those things placed on the board. Dr. Clayton had a very isolated opinion about Aaron Dean. 3 other psychologists disagreed with him. He was hired by the Fort Worth Police Department. Dr. Clayton didn't follow Aaron around the church. He didn't follow Aaron around in the choir. He didn't follow Aaron around in engineering school while he was getting his physics degree. Dr. Clayton said he could fly a commercial airliner. At least that's how I took it, which tells you the subjectivity of the discipline of psychology. Dr. Clayton had a very isolated opinion of Aaron Dean. Look at the opinion of the people that know him best. Of course his family's going to testify. That's who he spends most of his time around. He's a family man. He's very involved with his family. Is that wrong? The prosecutor tried to make it seem like that's wrong to be a family man, to be around your family, to be in church with your family. It's not wrong. That's not a bad trait that Aaron has. That's a good trait. He had an isolated incident as a late teenager in college. You heard that Aaron was homeschooled. You heard that the purpose of the homeschool club was to help people socially adapt to college and the college environment. Is Aaron going to be judged for one isolated instance in his youth? An incident, no doubt, he is deeply embarrassed about and has been since that day. A teenage mistake. You know, if there had been anything else in his background, speaking of people that didn't testify here, if there had been anything else in his background, they could have brought it to you. There are 190 prosecutors and 60-some investigators in that office could have brought it to you. You didn't hear about anything like that. They could have brought you police officers. If he had messed up anything in training, they could have brought those officers to you, and they didn't. Detective Dugan came to testify because he and Aaron developed a friendship while they were riding around that squad car together. A friendship that they've carried on after this event. Detective Dugan told you Aaron was devastated, as you would expect a Christian man to be over the situation. Deterrence? What about deterrence? One thing prosecutors like to argue at the punishment phase of a trial is that the jury has to send a message. You've got to send a message to the community. You've got to send a message that this type of thing isn't tolerated. Well, ladies and gentlemen, in this case, you have to be very, very careful of the message that your verdict sends. Because in addition to the folks here in this courtroom, this case is being followed region-wide. And the police officers that have been here and the police officers that are watching need to know that when they leave, and their families need to know, that when they leave for work in the morning, that they can follow their training and they can defend themselves. Your verdict must walk a very fine line between what you believe Aaron Dean did and what other police officers in the same or similar circumstance might do. Because this situation, this exact situation, is an extremely isolated event. It's a one-of-a-kind fact scenario. And your message needs to be tailored. If there is a message, it needs to be tailored to this event. Because the policing, the training, the methods involved, those are out of Aaron's control. You heard Judge Gallagher's in charge of the probations in this court. Judge Gallagher's in charge of the terms and conditions. And you can trust Judge Gallagher to make sure that this matter is followed up on. And make sure that he knows everything that there is to know about what's going on with this probation. And Judge Gallagher can tailor the terms and conditions. He could take and put Aaron in jail for the weekend on the anniversary of this event so that Aaron never forgets, which he won't anyway. Judge Gallagher could order Aaron to sit down with administration from the Fort Worth Police Department, any other regional police training academies, and help them develop training curriculums so this situation never repeats itself. Aaron Dean can be an asset to law enforcement. he can follow every other term and condition of probation that Judge Gallagher set out for him. Punishment, rehabilitation, and deterrence do not include the term revenge. And believe me, there are plenty in this community that are seeking that. But that's not the function of a jury. The function of a jury is to follow the law,
Why would you
and
mention
set out the
that
terms and
community-
conditions of probation that
Oh,
are
man.
applicable, or to make a decision that's applicable and based upon the facts of that particular case. There's no one else in this community that has heard all of the testimony and seen the demeanor of the witnesses and had your experience. This is your verdict and your verdict alone. And let's make no mistake about it. We are asking you to recommend to Judge Gallagher that Mr. Dean have his sentence probated. Because there is nothing to gain by sending this man to the penitentiary. No one can punish him more than he's already punished himself. We've talked about his need for rehabilitation. And we've talked about what exactly is it that we would deter by a penitentiary sentence here. What exactly would that be? Aaron didn't know who was on the other side of that window. As much as people want to make this a racial issue, it's not. He didn't know who was on the other side of that window. All he knew was they were armed and they were a threat.
How about he had reason to believe they were burglars?
So everything that's happened from then on is of low value in deciding what the sentence should be in this case. We had to file, the law requires that a motion, an application for probation be filed pre-trial, as the judge tells you in the jury charge. That's because both sides have to have the ability to question jurors such as yourselves about your ability to follow the law and to give fair consideration to the concept of probation, which all of you said that you would do. Every one of you. And ladies and gentlemen, on Aaron's behalf, on behalf of police officers and those who risk their lives on a daily basis to keep us safe, we're asking that you give that concept fair consideration here. Because this case deserves that fair consideration. Aaron deserves that fair consideration.
You have 2 minutes, Mr.
Thank you. Stand up there. Ladies and gentlemen,
What?
God, I thought that-
This
You
is
had 2
Aaron
minutes.
this is the man
Oh, okay.
that you'll be passing judgment on.
I thought that was
in a
it.
few minutes.
Wow.
You heard from family and friends, members of the community that know Aaron the best. He's a good man. He's a very good man. He's a very good
Very,
man
very good man. Repeat that for 2 minutes.
who finds himself in a very tough situation. And we're asking that you take into consideration all of those good qualities that you heard about. Because this man possesses all of those. Those people got up here, those people got up here, and everything they said was heartfelt. Because they know him best. Ladies and gentlemen, you have Aaron Dean in your hands. Like
No
the prosecutor
client's good at
asked me to
picking
do, I
lawyers,
hope
folks.
you remember my remarks. When you go back into the jury room. It's like at the first phase of the trial, the prosecutors get to close here. They get the last say. I don't know why. but that's what the law allows. So I'm asking when you go into the jury room and start your deliberations, that you recall the things that I've said here this morning. And you take all of those into consideration. And you arrive at a just and fair verdict. Thank you very much.
Oh, the shouter.
Yes, sir.
The shouter is back.
Turn my volume down now while I'm thinking about it.
Here we go.
He's ready. The sleeves could be a bit longer on his suit coat.
May I please court?
Yes, sir.
Ladies and gentlemen of the jury. Probation. You said you'd consider it. You never promised to give it. And I want you to remember when the probation officer was on the stand. 15 minutes a meeting. Maybe up to an hour, but that's usually just the first one. 15 minutes a meeting once a month. 3 hours a year. That's what that comes to. That's what that comes to. When you say probation, if you're considering probation for him, what you're saying is what happened that night, in the early morning hours of October 12th, is only worth 3 hours a year for that man. Probation is not appropriate, and you know it. So let's talk about what is appropriate. Let's talk about what the defense attorney said. He's punished himself enough already. You can consider what he told you from this witness stand. When he took the stand a week ago today, that morning, that seemed like a man who had punished himself, or a man that had given himself an excuse for his conduct. And the defense attorney told you this is an isolated incident. You know why it's an isolated incident? Because other officers don't act this way. Other officers don't make the same decisions that he made. That's why this is an isolated incident.
Right.
It's because of him. It's because of who he is. He had a good family. He had a good education. He had a good support system. So why is he here? He's here because of who he is.
He's a bad person.
I want you to watch that body cam video again. I want you to look at every decision that he made that night. I want you to look at every time he had the opportunity to save Atatiana's life, he made the wrong decision. And then I want you to look at that in the context of what Dr. Clayton said last week. Because it should all be clicking in your head now. That's who he really is. He's manipulative. The overconfidence, the narcissism.
No, the
Ideas of
psychologist didn't say he was
grandiosity that he can
manipulative.
do anything. He flaunts the rules. He runs in, just like I told you. Now when you hear that, the hard charger, the gung-ho, that's who he is.
What I want is
Because those
milquetoast
decisions
police
he
officers
made
that
that
hesitate,
night.
overthink things.
It
and
didn't
don't
just that when that
respond
split
quickly.
second when he
That's what I
pulled the
want.
trigger.
The only person who's ever said hard charging and gung ho is this prosecutor.
That backyard was who he is and his personality traits and what he can't change. So that's why we're here. It's because of him is why you're sitting in these chairs. You're judging him for what he did. You're holding him accountable for the choices he made. And now you do have to ask yourself, what is Atatiana's life worth? What are you going to tell her family when this is over? Atatiana, she'll never be married. She'll never have a family. She'll never get to be a doctor. She'll never grow old.
Diabetes will be
Her
here
mother.
for a generation.
Live longer than her. Mom living longer than a child. At 28 years old, she died. And this wasn't some tragic accident. He's the one that set everything in motion. Her sisters, her brother, Zayd and Zion, they'll never hug her again. You saw the defendant's sister touch her hand as she left the stand. That close human contact of support. A touch that any one of her family would give anything for to have one more opportunity to experience. But they can't. not because of anything that they've done, not because of anything that Atatiana done, but solely because of the decisions that he made on October 12th, 2019. And that's why he's sitting in that seat. And that's why you're making this decision. So what is her life worth? What are you going to say to them? What are you going to say to this community? She was in her home. I've said this before, but that's because it's so important. Where else? Where else should you feel safe? Not in your own home. She didn't ask for this. Her family didn't ask for this. It was him. So what is her life worth? We've talked about who the defendant really is. We've talked about Dr. Clayton. We've talked about Atatiana. This person, the defense, all they want to talk about is the defendant. This is the person that lost her life. This is the family that lost a loved one. This is two nephews who lost an aunt, two sisters who lost a sister, and a brother who lost a sister, and a mother who buried a daughter. A woman who went to college. She wanted to be a doctor. She wanted to contribute to society. And we've all of us, you included, have been robbed by the defendant.
Now we'll never have that cure for diabetes.
Yeah.
Is that okay?
It's another
Is that
generation.
worth 15 minutes a month? 3 hours a year? Is that really what you're going to tell this family? That that's what this is worth? 15 minutes a month? It's not. And you know it's not appropriate. The defense attorney said a tragedy that'll never be changed. He had so many opportunities to make other decisions so that we wouldn't be here. And yet he didn't. He continued to push forward because that's who he is. His overconfidence, his personality traits. And we go back to Dr. Clayton because it's so important. And if someone back there starts talking about his family and the good person he is, and I have no issues with his family. It's about him. That's what you need to direct him back to. It's about him. Who is he? Dr. Clayton told you. And the best evidence to show you, to look into his soul, to tell you who he really was, who he really is as a person, and why Dr. Clayton was spot on in his evaluation of this defendant was whenever he finally got into that room. And take this back and watch it again. Finally got back into that room, and Atatiana was taking her last breaths on the floor in front of her nephew, gasping for air,
Fake crying.
struggling to live, and he stood over her, lorded over her, providing no aid, not attempting to do anything, only looking for that gun to give himself yet another excuse for his behavior.
You have 10 minutes, Mr. Smith.
That's his heart. That's who he is. And she deserved better. She deserved better from that defendant. And she deserves a sentence from you. Don't just stand there and watch this happen. Take action. Atatiana deserves it. Give him the maximum. That's what her life is worth. Give him the 20 years. Thank you.
Okay, retired junior jury room. If you need anything, let me know.
Okay.
Hey. Just in time. Got my chicken soup.
All right. Hey, welcome, Steve. Welcome, Jeff. So the same continuing nonsense we've seen from the prosecution throughout, and the same weak defense we've seen throughout. This is just a horrible trial. These are an unjust conviction. We know we can't have confidence in the conviction because the state explicitly lied to the jury about what the law is, and was allowed to get away with that.
And it's more than that. In fact, I know we're working on some stuff, but the the problem is the closing arguments were so bad that I just don't know what the jury decided.
Right.
The problem with the closing arguments the way they were is that what did the jury decide? They saw some evidence and they heard some arguments from attorneys that were not the law. And as Andrew covered, because he's the expert on law of self-defense, and I think there was a fundamental misunderstanding of what the law was, and nobody in the courtroom seemed to be aware of that. And then on top of that, every other argument that was made to the jury was, in my opinion, improper. So what is the jury deciding when they come out and they say, we decided this because of X, I'm not like for the cop or against the cop or for the woman who died or against the woman who died. I want to see a fair process. And I have no confidence in what they decided. I don't know what they decided because it
just doesn't make any sense.
Yeah. It's just a bunch of emotional appeals.
So
he's a good guy, he's a bad guy.
It was clearly an intentional shooting, right? Sure. There's no contrary evidence, but that he intentionally shot her. And if he intentionally shot her, it's a murder conviction, not a manslaughter conviction, unless they believe it was self-defense. So they didn't convict him of murder, so they must have believed it was self-defense. And if it's an intentional shooting, it can't have been reckless.
Well,
and no one argued that anything about his use of force itself was reckless. They talk about him crossing the street or slicing the pie on a doorway, but none of those are the things that killed Atatiana Jefferson. What killed her was his drawing his pistol at the sight of a gun and shooting her. That's not reckless.
If they're deciding it on the law, but you're looking at it from a rational law thing. But it seems to me that all the appeals to this jury were emotional appeals. And I've been working. I'm at lunch right now, so I'm going to have to duck out here within an hour. But I don't know how long it's going to go or what's going to happen. But the thing is, it's like, okay, what I picked something up and I was listening through it. What about all the witnesses that you didn't hear from? Yeah. They would all agree with me. Well, what the hell is that?
Yeah. All facts, not in evidence, obviously.
Speculate on what's out there. And it seems to me the state's in just as much a position as the defense to call whoever witnesses they have.
Right. And the state's testifying, right? All this talk about gung-ho, hard charging, the only person who ever said any of that was that prosecutor. Right. No witness ever said that. They're mischaracterizing the psychologist, even the psychologist who didn't like the defendant. Never said he was manipulative.
And the defense attorney brings up, well, like that they crossed that I thought the only thing they did right was the cross on that one expert that the state had. But one of the things they brought out on the psychologist expert, which was completely inappropriate testimony as far as I was concerned, but what do I know? I'm not a Texas lawyer, but they said, well, you're one of 4 people and you're the only one. The other 3 experts disagree with you, right? Well, where was the defense? Where were the other 3 experts?
Right.
Why didn't the defense bring those other 3 experts on? What are they doing? If that's true, which I imagine it is, I mean, the state seemed like they agreed with that too. But we don't hear from, you are there to advocate for your client. And there's 1 expert that's against you and 3 that are for you. Why don't you call the 3 that are for you? I don't know.
Yeah, it's absolutely crazy. And then that closing. So Steve and I worked this weekend on producing a version of the state's closing argument by the prosecutor Diener, in which we actually counted up all the improper closing arguments she made. It's over 60, folks, in a 15-minute closing argument. 60. And by the way, the first couple of minutes of that video, I only counted, it's like whole paragraphs, each sentence of which is arguably improper argument, but I treated that as just one improper argument.
Well, and we're going to fine tune that because actually some of this participation, what we do, of course, I'm at lunch here, but working on these things, I train our trial division and I train trial attorneys to do things like this. And I'm going to turn this closing into an example and into a seminar for our attorneys on how to identify improper closing arguments and how to object. And I'm going to use this tool that you and I are working on, and I'm getting Ryan Bellinger on board too, so that we can do this as well as we can to diagnose all the problems with that first closing, because it's only 15 minutes. And when we went through it, we only identified 1 paragraph, which was like 3 sentences that was proper argument. Everything else in that closing was improper. And I want to be sure about it because, I mean, you know, I gave you my reasoning on it. I mean, it's like, and I'm not a Texas lawyer, but it's a good teaching example for us Florida lawyers so that, you know, I don't have any clue what's going on. This is clearly a political trial. Is this the way it's done in Texas? I'm befuddled. If it is, I mean, I'm glad I'm in Florida. I don't know. I've never seen anything quite like this trial. It's a political show trial. And
so, Steve, I did produce a 2x speed, double speed version of that little video clip I sent you. Should we play it?
Well, it's up to you. It's your channel. I would say it's not completely fine tuned.
Yeah, let's consider it a draft. This is a first draft of the video, but I think it might be it might be fun for the audience to see.
What is the poll? Maybe they should super chat you or something, or like if they want to see the draft version, because.
Yeah, I don't know. Do people want to see the draft, or should we wait until we?
Sure.
Let's give some super chats. In fact, while people are putting in their recommendations, and we'll do the voting by super chat, or by comment in the law self-defense dashboard. Of course,
I don't think that this is even it's not even a liberal conservative divide. I mean, I don't really see.
No.
I don't.
Well, you have the cop haters in the chat, right? So they just want this guy burned at the stake, but they can't give any reasons. It's all emotion. There's no law or evidence.
Which is what
they're just angry at the police.
Yeah. Well, I'd be interested. Maybe we can get a little feedback from.
I think it's so funny because they're mad at the police because they hate the state, right? They're anti-state. The state's overbearing, and there's a lot of truth to that. But in calling for the lynching of this cop, it's the state lynching this cop. It's these prosecutors that are doing this. So ironically enough, these are the prosecutors that would be going after them if they were defendants in Texas.
Yeah, is this the way that we're going to try cases based on the community wanting to lynch somebody that we don't like everybody out here is expecting you to convict him. That's the argument. That's the way we're going to conduct trials now. Or that family they lost somebody, therefore you must convict because somebody got killed. Really? That's the argument. I mean, everything here is so improper. This whole sentencing phase, I'm not in tune with at all. And I'm not a Texas lawyer, so I'm clueless on this. So I'm just going back to the closings on the guilt phase, which are outrageous.
Well, how much of this could have been avoided if they had made the proper objections and put a stop to this nonsense during the closing? Then they could have taken, I think, a lot of the edge off the political nature of this and the arguments that, well, somebody died, so therefore someone needs to go to jail.
Well, I think the defense. See, one of the questions I have is this judge, because clearly the judge has command of the courtroom. All right, I think it's very efficiently run courtroom. Here's an example of a judge who is demanding the respect of the parties. Fair enough. But is he a bully tyrant type that if you are a defense attorney and you start objecting, that he's going to start, that's out of line, counselor, and he's going to start threatening you with contempt of court and sanctions? You know, he may have a reputation of being such a tyrant, and that the defense attorneys are cowed into being little puppy dogs and not objecting on closing arguments because they've dealt with this judge before. I don't know. I don't have any knowledge or insight. Or are they just lazy and not on top of it? Are they? I don't get anything that's going on here. So that's why I asked the question. The judge may be great. The judge may be terrible. The judge might be the reason that defense is operating that way. I don't know. I'm speculating.
No, but I don't think that's why, because there's opportunities for the defense. They could have in their own closing, for example, pointed out what the actual law of self-defense is, instead of buying into the misrepresentation that the state offered. They could have addressed what's required for a finding of recklessness, because it doesn't exist in the record.
And the one objection that they did make was sustained.
Right.
And the judge instructed the jury to ignore the comments. So that kind of belies that theory, doesn't it?
Yep. So they obviously, that suggests to me they could have objected more. I would have. I mean, come on. You object until you get threatened with sanctions, at least, right? I mean,
right.
You don't not object because you're afraid sanctions might be threatened. I mean, that's ridiculous.
Well, advice is, have you seen this closing?
I didn't see the female prosecutor's closing.
Okay, that's the
I
best
just saw
one.
Shouty McGee there shouting at me at the end.
Crazy stuff.
All right, so I'm going to play the normal speed version of that closing, annotated by Steve on the legal merits, and I did the post-production work to add in the effects. So if the effects are kind of sucky, and I will concede that they are kind of sucky, that's on me. And of course, Steve and I were doing this over text, so we haven't had a chance to like comprehensively together step through it. So this is very much a draft.
Well, and we're going to use this. We're going to fine tune where the objection should come, because I was operating off a transcript this weekend.
Right.
And so then I placed the arguments according to where I thought they looked good on the transcript. But that's different from how you hear them in court. So they might be a little off timing wise, but they're connected into the substance of what she's saying rather than the tempo of what she's saying. So if they're a little off, it's because of that.
Okay, starts a little slow and then it picks up. Here we go, folks.
Where can we feel safe? When you think about your house, you think about safety. It's where you go to retreat, to get away from the world. It's where we grow up. It's where we have kids. It's where we mark on the inside of a doorway, and they've gotten taller and taller. It's where we make memories. That's why it's so sacred. That's why it's so important. How many of us during the Thanksgiving holiday were in our own kitchens celebrating with our family? Christmas, right now, how many of us right now have a Christmas tree in our living room? Why do we do that? Why do we put Christmas lights outside our house? Why do we decorate our homes? Because they're ours, right? Because they're so important. And today, that's exactly why this day is so important. Because the sanctity, the safety of our homes has been compromised by what he did. He took her away, 28 years old, the rest of her life at the hands of this defendant. The Fort Worth Police Department has good officers. In fact, I've worked with some of the best officers in the state in my career. I trust them with my family. They actually do serve and protect. They don't have preconceived notions about the East Side. They don't go to certain parts of town and say some deserve to be served and protected, but not others. Only the good parts. Only the parts of town that I want to go to. That's not how it works here. Because our community is all of us. And it was her too. And despite what he thought, when he went over to that house, it wasn't a dope deal gone bad, a robbery or a shooting, high crime area. This is a 28-year-old woman that was a daughter, a sister, an aunt, studying to be a doctor, taking care of her nephew. Yolanda, her mom, was a good person. Zion was a good person. James Smith still lives on the east side. He's a good person. His family are good people. When you put on that badge and you put on that uniform, you say you're going to serve and protect us all. That means her too. And the Fort Worth Police Department, those officers that do serve and protect us and don't have those preconceived notions, that did a thorough investigation in this case are ashamed that they ever called somebody like him a brother in blue. Because it means something when you put on a badge. It means you don't go to a house with a preconceived notion because you want to have that kind of power. Haven't we all met an officer that just likes being an officer a little too much? I've been pulled over by those guys before. Power hungry, tunnel vision. It's a little scary to me. Those people that we don't.
Object to that being outside the record and an expression of the prosecutor's personal opinion, which is absolutely irrelevant to this jury.
Sustained, stay within the record.
Ask the judge, ask you to instruct the jury to disregard the last comments of counsel.
I didn't hear a bell. I was like, what? You're going to let that one through?
And throughout the course of their entire investigation, what did the Fort Worth Police Department determine? They talked to all of these witnesses. They looked at all of the evidence.
The count is unobjected to improper
what
argument.
you guys got over the last 2 weeks. That's what they had. Forensic interview from Zion, witness interviews. They talked to folks, the autopsy report, the photographs, the body camera video, frame by frame by frame, just like what we watched. They went through all of that and they determined it's murder. They issued an arrest warrant and a district judge signed saying this is murder. The question in this case has never been, is it murder? The question that they raised this week was, is it self-defense? Is it self-defense? And what's really important about the court's charge is this is the law that applies. We do not view it based on what he says and only what he says. A person doesn't get to harm another, get up on the stand and say, well, I was doing it in fear of my life. And we just let them go. We just take their word for it. Imagine that scenario. Imagine what would happen if that were the law. Then not one single person would ever be held responsible and accountable for what they do if they can just say it is, so it is. That's not the way that it works. What the law is, and what you guys have in front of you, is that it has to be a reasonable belief and immediately necessary. And so how do we define what's reasonable, right? That's also in your court charge. It's a belief that would be held by an ordinary and prudent person. All of you guys, with what he did out there, was that reasonable? Was that immediately necessary? And here's one very important part, and I can tell you right now, when they get up and talk, they don't want you to focus on this. This is the law. This is what we're charged. This is what we're bound by. Unlawful deadly force. Unlawful force. The only way that this conduct is justified by this defendant is if it's reasonable to all of you, what he did, immediately necessary. And the most important part is her, meaning Atatiana's, unlawful force.
What a gross misstatement of the law.
Or unlawful deadly force. The only way he
list out
is
those
justified
three important
his
words right
conduct
before that.
is that it's to the degree the actor reasonably believes the deadly force is immediately necessary
See,
to protect the actor.
The actor must
The actor being the
reasonably
defendant against the other person,
reasonably
Atatiana's use of unlawful deadly
Or
force.
attempted
So
use.
think about that for a minute. What has been unlawful
Perceived attempted use.
about what Atatiana did? We have not seen one shred of evidence that anything that Atatiana did was unlawful. In fact, we heard quite the opposite. You can be in your own home, owning a weapon, owning a gun, and you can protect yourself in your home. That's one of the most fundamental rights. That's the reason we all feel so safe. Atatiana Jefferson didn't commit any criminal act by walking up to the window with her gun.
It's not the legal
thinking
question.
someone was outside.
Nope.
It's what many of us would do. if we were in our house in the middle of the night in the back bedroom and we hear somebody outside, that's what you would expect us to do, to try to protect ourselves, and in this case, Zion as well. So there's not been any evidence to support anything that she did was unlawful. And you got to have that. That's what the law says. And if you think about it, it makes sense in this case because she was in her own home. If we can't feel safe there, where in the world are we going to feel safe? This defendant, when he put on this uniform, he has a tremendous amount of power, right? A tremendous amount of power.
She loves the power.
And when we talk about what's reasonable,
Gung ho.
when I talked earlier about the Fort Worth Police Department, when they went through and they did their thorough investigation of what happened out there, they considered all of what you guys have seen as well as the general orders. I put that in here too. You guys can ask for that. If you guys want to go through, you can ask for the general orders. You can see exactly what they say. It's not about what I say they say, or they say, or any kind of spin that the defendant wants to put on it when he took the stand. It's exactly what is written down. It's the very thing that the defense said in opening statement. They followed all the steps and procedures as you are supposed to. An open structure is a silent alarm, and he did everything right. That is what this Jay Coons got up here and said. He wouldn't agree with anything that we asked him, but that's the one thing he said. Everything he did was right. Well, that is not the case. Very first thing, officer receiving the call. That's him, right? He's the sheet officer. He's the main officer. He calls the shots. Step 2, B, all main exit ways should be guarded so as to prevent the escape of any defender. We start there and we fail. Right? And that was one amongst the many
That didn't
many
kill
things
Atatiana Jefferson.
that he did wrong. Because it wasn't important to him to serve and protect that day. It was important for him to get there, get in the action. Power. It can corrupt certain people. Certain people don't
I know a
need to
few
wear
people
a
that might
badge.
be corrupted with
Certain
power here in
people
the courtroom.
do not need to have the power and the control if they do not respect
You
the
have a power
accountability.
count too.
And in
She
this case, the
should hold up a mirror to
grave
her right now.
effect that it had. Now, you guys have the ability today, over 3.5 years, we've waited. They've waited. They've waited for this day.
They like to point a lot.
Everybody in this room and all the rooms outside of this room and everybody in this community has waited for today. Because today you say you can't create the danger and then claim self-defense. We want to feel safe in our own home. Today, you guys' decision in this case, finding him guilty, says, I'm holding you responsible. I'm holding you accountable. I'm following the law. And with the power you all have today, which is more power today to change lives, to hold people accountable than most people have in a lifetime. The power you guys have today
Convict him because you have the
is to
power.
hold him responsible.
One ring to rule them all.
Be power hungry,
It's to tell them
my precious.
that it all wasn't in vain. It's to say that she matters. They matter. East Side matters. We protect everyone. And the law agrees. Everything in this case, all of the evidence in this case, is demanding a guilty verdict. That is exactly what we are asking for from all of you today. We know
She doesn't even say of
what
what
he
charge.
does with power.
Just return
What are
guilty.
you guys gonna do with it? You find him guilty.
That's it. So yeah, definitely need some fine tuning. Steve and I will get on that, but I think we'll have something very useful for educational purposes.
That was good.
Yeah, all the gross misstatements of the law, like the reasonableness in the self-defense statute, and she's asking, well, what did Tatiana do that was unreasonable? But of course, that's not the legal question. The question is the reasonableness of the person who used defensive force, not what other people are doing.
Right. It's not the objective. It's not the objective state of legality of the decedent. It is the subjective view of the shooter and their perception and whether that perception was reasonable. So it is not whether she was objectively acting within the law is a question. Okay, that is not a question. That's not a question for the jury. If you read the entire instruction, it's whether the officer reasonably believed that he was in imminent facing an imminent deadly force threat. Even if that we look at it in hindsight, we say that was objectively wrong, meaning that she was operating legally. Did he perceive it that way? Because he's to be judged for a guilty mind, because we punish criminals for improper mens rea, having a criminal mindset. If he is reasonably perceiving a deadly threat, even if that is wrong, he does not have a criminally culpable mind and should not be punished. That's why this instruction reads the way it is. But by buying into this objective test on the lawfulness of the act of the decedent, we are now taking that mens rea away from the shooter and putting it and basically destroying the self-defense law. And so a lot of those misstatement of laws were Andrew's bag. And I mean, that's what we were talking about the whole time. The defense bought into that reading of the statute.
Yeah, absolutely. It's a travesty. It's just obviously it would be incoherent to judge someone's use of force in self-defense based on the mental state of other people. It could only ever be judged by their own subjective perceptions of what's going on, by the standard of whether or not that subjective perception is objectively reasonable. Would a hypothetical, reasonable, and prudent person in the same circumstances have shared that belief? Not what's in the minds of other people. We're not mind readers. Even if we weren't under the stress of an apparent attack, we don't know what other people's mental states are. So I put a poll up on YouTube on the appropriate sentence, what people think the appropriate sentence, not a prediction of what the jury will do, but what people think would be appropriate here. 20 years max, 8%. More than 10 years, 14%. So that's almost a quarter for 10 to 20. Under or equal to 10 years, 24%. And probation, 53%. So a majority think that probation would be the appropriate sentence here. That's out of 1,000 votes over the last 20 minutes.
Honestly, I don't know if I have an opinion on sentence. I have an opinion on the trial, in the fact that I don't think the jury was given a proper question to answer. And so I don't have faith in the verdict and the outcome of the guilt phase.
I mean, she never made a legal argument in her entire closing. Even when she asked them for a verdict of guilty, she didn't even say guilty of what? Guilty of murder? She didn't make an argument for murder.
And this whole insinuation about East Side and that he's this racist cop, she implies that throughout her closing. She puts it in like, he doesn't care about the East Side, but we are all the good people and we are against these people. We got to send a message that we're against people who look down on the East Siders, and they matter. Mm-hmm. That whole line of argument is so out of line.
And he's not charged for not responding to a call from the East Side. I mean, he's in this situation because he responded to a call.
Well, she didn't ask for this. Well, he didn't ask to be on that call either. He was assigned. He did his job. He went.
And I would like, ultimately it's kind of, Andrew, I really do not have a dog in the fight. I want the jury to make the call, the proper factual call based on proper evidence, proper legal arguments. Like, I'm not certain that the defense didn't, What did they call? What was their defense? Who were there? Where were their witnesses? It seems to me there's a lot of witnesses that were not called that should have been called. And I don't know. It's the whole thing is strange to me. And I mean, it's obviously a political prosecution, and I'm not good at political prosecutions. I mean, I believe in fair trials and good judges and good defense attorneys and good prosecutors. Like the one Vices, we covered that one up in Tampa.
Yeah.
That was almost, except for the one cheating by the state.
Yeah, you didn't like that one little bit, whatever.
The one little bit, but other than that, that was a very cleanly run trial by all parties, defense, prosecutor, judge, and the jury probably got it right there too, wouldn't you say? I mean, guilty, and then he got life in prison. I think that was probably the right call. On
I mean, during the entire 8-day trial, I think there was maybe 7 or 8 objections by either side during the entire thing, because it was just above board, it was straight, it was by the books, it was by the law. Everything was stated correctly, clearly. The questions were fair. We didn't see any of that here.
I don't.
And in this particular case,
I don't recognize this trial. I don't recognize what they're doing here as being. And I'd love to hear from Texas trial attorneys, because is this courtroom? I mean, obviously, these prosecutors, this is what they do every day. This is not the first time they've done this. I mean, you can see they got this polished, and they've been allowed to get away with it. Nobody's called them on it. And
and the defense should have seen this coming. I mean, the defense knows what the evidence is. They know what the law is. They know it's not on the side of the prosecution. So the prosecution's not going to be arguing law and evidence. They're going to be making emotional arguments. They're going to have to misrepresent the law. All of this is completely foreseeable from the defense perspective when you go into this trial, and they completely bungled it. They just let the state do that. It's like in a football game. You know what the other team's good at. You have to take that away from them.
Well, Vices, what do you think? That's the first time you've seen that?
I saw the first little bit last time we were all together, but I mean, I didn't like anything about the openings, and I liked even less about what we just heard for the sentencing. It's just wind. It's hot wind. It's pointing. It's emotion. It's yelling. It's shouting. It's whispering to be emphatic.
Well, there is this drama thing, and a lot of prosecutors do it, and some defense attorneys do it too. Let's be fair. There's this whole theatrical aspect of it, and I tend to be pretty dramatic. I get emotional and committed to my trials, and when I believe it, I argue passionately, but I don't believe their passion.
You don't choreograph it.
It feels choreographed.
Clearly, Shouty McShoutface there was all about the. You can tell he was in the mirror practicing this.
Right. And when you hear from the witness, you will find, right? This like all these hushed tones, and then the looking and the pointing down and the condemning and the that's not who we are.
You missed the one windmill just before you got here. He did one of these.
And I just don't believe that's to me, juries see through that falsity. But I don't know. We're just commentators here.
Yeah, and even the stuff she tried to point out, like it was evidence of recklessness, like, oh, the procedures say that the door should be guarded so the bad guy can't get away. That wouldn't have changed anything. If he had left Officer Darch behind at the front door and proceeded as he was doing, it wouldn't have changed anything. He would have looked in the window. The gun would have been pointed at him. It's, when you think of recklessness, folks, the claimed act of recklessness has to have some proximate relationship to the harm caused. So we think of a reckless homicide, a reckless murder might be drunk driving, right? Someone gets drunk, gets behind the wheel of a car. They don't intend to run anybody over. They're just trying to get home. But because they're drunk, they run over a pedestrian. They knew they were acting recklessly, meaning they were creating an unjustified risk of death to another person. And then the death results, you have reckless manslaughter. But what is not recklessness is if they ate a unhealthy breakfast that morning, or it has to be the act of the recklessness. They didn't tie their shoes were unlaced while they were driving. That's not what caused the death. That wasn't the recklessness. Could they have done that better? Could you have tied your shoes better? Could you have eaten a healthier breakfast? Could you have gone to the gym that morning? Wouldn't that have been the more responsible thing to do? Okay, sure, whatever, but that's got nothing to do with you running over the pedestrian. Here are all these things they point to: the way the officer crossed the street, that he didn't leave the other officer, his partner, behind. There was no decision that would have been the right decision here. Prosecutors love to do this. If there's 6 choices you could have made, they could all be reasonable choices, but you can only make one. They'll say the other 5 were the ones that you were supposed to do. If he'd left Darch at the door, they would have said he was reckless for leaving his 6 unguarded. If he had checked the garage, they would have said that was wrongful because he didn't have probable cause to go in the garage. Or if he's looking in the garage, he's not looking at the house where the burglars are supposed to be. There is no right decision.
I think one of the big issues that people are focusing on, they tend to focus on, is this they didn't announce themselves. That's the policy. It was like, who would do that? What cop would not announce themselves? He's following the policy. If you don't like the policy, change the policy. If he does announce himself and there's somebody in there and they kill a hostage, they blast through the door and get the police officer. If they do announce themselves and things go wrong, well, then you violated policy. As you're just saying, it's a damned if you do and damned if you don't situation. You just have to look, was he operating within or outside of the policy?
Well,
I
and
don't
I'm going to
think
use
procedurally where he did things wrong.
I'm going to use a golden rule argument here for anybody who's questioning what we're saying here. And let's just say we all drive. We're all drivers. Envision yourself driving down the road, obeying all the traffic laws, and it's nighttime, and some little kid runs out in front of your car. You don't see him, you hit him and kill the little child. You didn't intend to kill the child. You accidentally killed the child. And you obeyed all the traffic laws that were around you, but an accident happened and somebody died. Now the state charges you with intentionally killing that child. And you can argue your defense is, I obeyed all the laws. It's an accident. I didn't intend to do any harm. It was something that happened, but I was following on the road and this kid ran out in front of me, right? Well, then all of these arguments the state is making would apply in your case. So they're going to say, let's have the value of this little children. Let's send a message from the community, and then misstate the law and say you had a duty to that because that little child, and misstate the law so that it changes things so that you're guilty and you've got to prove that kid was doing something wrong.
Right. 3 blocks earlier, you didn't use your turn signal indicator.
Right. All the things that you did leading up,
right.
And that the kid was not acting. That kid was a good kid. I've talked to every driver around and they avoided the kid and they all condemn that child being run down. And you've got to agree with me because this kid, all of these arguments would play into a situation like that. And you're on trial for murder for a little kid and it's an accident. This is the courtroom. This is law. I mean, you see,
and of course you're a white driver. It's a black child in a black neighborhood. So they start insinuating that you ran the kid over for reasons of racism.
Right.
And where you go is you go for the negligence, not the criminal behavior. You don't throw the cop in jail for following the policies. You sue the shit out of the police department for their negligent policy, if you believe that's the case. And that's where you get your compensation. That's where you get your revenge. That's where you get the restitution.
Now and we are not punishing culpability of a mind if it's an accident. So that's the question the jury should have been deciding. And that they are not, I don't have any confidence that that's what they decided at all. But who's telling them that that's the way that they should have decided this case? So if they had come back guilty of manslaughter and they were correctly instructed, we wouldn't be here saying what we're saying here today. Another big failing of the defense is they let the state on cross of the defendant go into all this stuff about grading himself. Right. And putting a letter grade and doing things right and all of that stuff that is irrelevant to the act of self-defense and his perception. And by doing that, you are basically changing the burden of proof from the state. That it says a burden shift, but really what it is they didn't really, I think they might have done it once, but they didn't explicitly burden shift, say the defense didn't prove. What they're doing is they are redefining the state's burden. The state's burden is to prove the person guilty beyond a reasonable doubt based on the elements of the crime and to disprove justifiable use of force beyond a reasonable doubt. Those are the things that the state has to prove. By saying all these other standards, is they a good or a bad person, or then they are basically changing the burden of proof for the state into proving something that's not at issue, that's not provable, that's not required for them to approve, but it's a lowering of the standard because now it's like, well, we're proving that the person was a good person. Okay, well, what's that have to do? You've proved something that doesn't matter and is not contested. The defense isn't going to come back. Same thing with like asking him on the stand, oh, he gave himself a B. He should have given himself an F. Well, I don't care what letter. He could get a 0.
Right.
That's not beyond a reasonable doubt, and it doesn't disprove justifiable use beyond a reasonable doubt, whatever grade he gives. But by changing the game, you changed the burden of proof on the part of the state.
He's not charged with jaywalking. He's not charged with imperfect tactics and slicing the pie on a doorway. Those are not criminal offenses. But that's what they urged the jury to grade him on. Hey, Steve, I know you're only here for lunch, so I want to make sure we mention your book. All that stuff, all those improper argument types, that's right out of Steve's book, right here. Ideas and Answers in the Law, 2nd edition. The 2nd edition has that chapter, right, Steve? It's not in the 1st edition, but I think people can only get the 2nd edition now. Ideas and Answers in Law, they can get this at where? Crimelaw.net. That's the only place. And by the way, the foreword is by none other than, you may have heard of him, attorney Andrew Branca. And I was very honored to be able to write that for Steve.
Well, it was a mutual honor.
Oh. Well, and on the back, there's Nick Requeta.
Yeah, Nick gave me an endorsement too, which was awful kind. But and this is right out of the book, and it's not just and everybody says, well, Gosney, you're just a critic, you're just an appellate lawyer who likes to criticize judges and prosecutors, which is true. But I will also say that I also used to train prosecutors, and there's 3 parts to that chapter, the added chapter in the 2nd edition. The first part comes from my training and how I would train prosecutors to do proper closing arguments. So the first third of that chapter is about how a closing argument should be done ethically and legally. It's simple. It's easy. It's the way there's a paint by numbers approach that is ethical, legal, upholds the law. And I'm not just saying they're doing it wrong and I don't have any good suggestions. I'm saying they should follow my model on how to do an argument. And then these are all these 7 types that we talked about and we graded. Those are criticisms of this. They're doing everything wrong. In fact, I thought one thing, we got a couple things we need to tweak on that. One of them is the one paragraph that she actually does right. We ought to note that over on the other side and say,
yeah, sure.
Proper arguments being 1, and it'll be 1 to 66.
Yeah.
And I also think we could it's probably more than 66 because
it is.
I've kind of grouped it into a paragraph when there were multiple opportunities for objections throughout the paragraph, but we kind of conglomerated into one because it was a general idea that she was pushing. We're working on improving this, and it's going to be a teaching tool for me going forward. So.
And Steve, folks,
this guy's idea right here, man. He's like, what do you think about doing this, Gosney? I'm like, that's genius.
And folks, you can also find Steve. I don't believe Steve has a YouTube channel, but I believe he has a Rumble channel. So you can, and what's that called? Your Rumble channel. How would people find that?
It's Crime Law with Stephen N. Gosney.
Okay.
You can see me in the mosh pit or getting crowd surfing at the Ginger concert.
Oh, nice. And Jeff, where can people find you?
Right there, Legal Vices. I should bring up my own little. Everybody else has the PowerPoint the file. I need to make something for my own channel.
Right, you got to write a book,
Vices.
man.
That's what I do.
You got to do a book on maritime law. Listen, I got Steve to do his book. You can do it, man. Just got to do
so
it.
Much more interesting than my book, though.
Well,
I got to find a way to make it exciting and interesting.
I used to come on these. Andrew he's the reason that book exists. Andrew is, because I would come on these channels. I'd come on his show or I'd come on Requeta's show or whatever. And then they'd say, okay, well, let's go around. Who's got something to grift? And I'm like, I got nothing. And Andrew got on me about it. He's like, Gosney, get it together. And so I'm like, okay, well, what should I put together? You got all these articles. Why don't you put them in a book? I'm like, you think? I'm so clueless, right? So here he is. He's got the genius creative mind, and I'm just. But he was right. as usual. But
Well, we
Speaking of
really are
books,
trying to build a,
yeah.
I'm trying to build a broader community through law of self-defense than just myself. I mean, that's one of the reasons we set up these American law courses. In fact, I should as well give a shout out to that as long as it's come up. American law courses, folks, these are law school level classes taught at a fraction of the time and cost of law school without the toxic politics of law schools today, taught by expert instructors. Steve just taught criminal law this past fall for the fall semester. In the spring, we have courses on evidence and property scheduled. In the summer, I believe we're doing criminal justice. In the fall, we'll have a criminal procedure or criminal law 2. We'll probably have constitutional law. And right now, until the end of the month, is the pre-registration period for the spring. You can save 50%. That's a lot of money, folks. Over $1,000 per course. If you go there and register before the end of the month, and I would encourage you to take a look at what we have to. We have interviews with the professors. You can learn all about the courses, their vision for the courses at AmericanLawCourses.com. And one of the reasons I was motivated to set up American Law Courses is because I'd like to develop a broader legal community with broader expertise than just what I can bring to the table. Ideally, in the future, to be able to assist on these kinds of cases in a more comprehensive way. So it's not just me providing an evaluation on the case, but there's also input from someone like Steve, from someone like Ryan Bellinger, who's teaching our evidence class, so that a defendant doesn't get run over by the prosecution because they have a weak defense. Because, folks, most people are incapable of making an informed decision on their legal counsel. They just don't know enough. They're completely uninformed consumers. And it's very helpful to have people on your side who, through exposure, like you get exposure to Steve, you get exposure to Jeff, you get exposure to me. You see us all the time. You can evaluate whether or not we're doing a good job, whether or not we're making good calls, whether or not we're subject to credible criticism that we can address by other attorneys. I'm on the internet almost every day making these arguments in an open forum. So you have a sense of our quality because you see us all the time. When you go to retain a criminal defense attorney, that's the first time you're meeting him. You don't know anything about whether or not he's competent or not, or skilled or not. So it can be very helpful to have people on your side who you already know you can trust to help make that evaluation, to make sure that, man, you're involved in a use of force event, anything we'd be advising on, you're probably looking at least 20 years in prison. Those are big stakes, folks. And you don't want to end up in the position where this defendant is, where it's not until the end of the trial he realizes, if he realizes it yet, that he's in this position at this sentencing because his defense team let him down. AmericanLawCourses.com.
Well, and we're going to tweak this. Ryan is going to go through it. I think I sent it to him to our little buzzer closing argument thing, because we're going to develop this as a teaching tool within our office.
You know what I'll do, Steve? I'll send you just a clean version of the closing without all the bells and stuff. Okay. So if you want to kind of run through the video with the transcript in hand,
what we're going to better timestamp the objections and maybe put them where they should be and what should be, because I did that off of a transcript, and also we might want, once we get it tightened up, we could also go into we could do like a stop-start video with you, me, and Ryan, and go through it individually and talk about, like, when we say burden shifting, what are we talking about in a much more in-depth, rather than, it's entertaining. It is very entertaining, but I love, it's genius. But also explaining what we're talking about, because it's like, well, that's not a burden shift. No, it's a redefining of what the state's burden is. So that would fall under the category of burden shifting.
Right.
And so that's the kind of thing that,
and also we could explain why these things are objectionable. Why is a golden rule violation objectionable? Why is calling for a conviction to send a message to the community, why is that objectionable? There's good reasons why these are objectionable closing arguments. And that this 14-minute closing argument could easily be a 2-hour class, because virtually every sentence of that closing was objectionable.
Right. No, it was. And that's why I was going crazy when we were watching it live. I was jumping out of my seat, and people were like, Gosney's going to have a stroke. But I mean, because I'm like, where's the objection? Where's the objection? The whole theme of the closing was an improper closing argument. The whole theme was a golden rule violation. And, and it's like, it's just shocking that the guy that she's letting these, and it's clear this is the way they do that in that courtroom. So don't have faith in the criminal justice system. And part of this is I don't want this to be the way that trials are done in the United States. I want the prosecutors to do the right thing. I want them to uphold the law by following the law. Is that too much to ask? And it's like I mean, a good prosecutor can keep a defense attorney in their chair by following the law.
Yeah, I mean, why did the prosecution in this case feel compelled to misstate the law so frequently?
That's the third part of the chapter of the book, because the first one is how to do it. The second one is how would they screw it up, and the third part is in that chapter in the second edition is why did they do this, and what are the remedies? What are my proposed solutions on how we could stop this as a society? Remedies for improper closing arguments, and what motivates, because and the reason is because they want to win. They want to convict the person,
right?
And that they think their job is to convict, and their job is not to convict. Their job is to uphold the law, and by following the law at trial, they are upholding the law. You give the jury the facts. The jury is the fact finder. You present a fair case. I don't care what I don't care how dirty you think the guy is, how dirty you think the defense is, how guilty the guy is. You uphold the law by following the law as a prosecutor. But when you think instead your job is to convict, that's when all of these things become justified. All of these arguments, because he's a bad guy, and you can see it in her eyes. She thinks that we're the good people, you and the jury, and we're standing up for good, and that guy, he's evil, and we're going to have cosmic justice created by putting the bad guy in prison. We're going to stop this once and for all by convicting this person. That first of all, it's not true. Second, it's improper argument. It's just wrong on so many levels. She's abandoning her role as an upholder of the law and becoming an advocate for guilt.
And no one's supposed to be convicted, folks, because they're perceived as being a bad person. A bad person. You're supposed to be convicted because the state can prove beyond a reasonable doubt each and every element of the crime under which you're charged. Not because other people don't like you, or you suck, or you're rude, or you're manipulative, or you're narcissistic, or you're gung-ho, or you think too much of yourself. Those might all be personality failings, and they may be people you wouldn't want to personally be friends with, but they're not crimes.
Well, and that whole personality, there was that personality test guy, and and I'm a big fan of the Big Five personality tests and Myers-Briggs, and it's helped me tremendously. I can't believe that was a part of the guilt phase. How does that have any relevance to anything? I don't understand. So he's got this aggressive, narcissistic personality, so he's guilty. I mean, well, that to me is it's not. And where's the defense team? I don't know. The whole thing is bizarre.
I think that psychiatrist was actually part of the sentencing phase.
Was it part of that? Yeah, but it doesn't matter. Doesn't matter, because look, I want the prosecutors to take that test, because I guarantee you they're aggressive narcissists.
Yeah. Yeah.
Well, I got to get back to work here. I'm sorry. I've just as my lunch break is.
No
over,
worries. Yeah, I'm not sure how long we'll go. I think Steve, if you got to go, that's fine. Thanks so much for being on as always. I'll hit some super chats and the member questions, but I'm not going to sit here online for all day while we're waiting for a verdict to come back. And it's unpredictable when it might come back.
You want me to stay for I got about 5 minutes if you want to stay for the super.
Sure. Let me hit some of these. Let me look at the member dashboard first. Question.
Appeal is a question too. All this stuff we're complaining about is waived.
Yeah, because they didn't object. That's why we pointed out the one objection they made in closing. That counter was actually, and I didn't count that as objectionable, even though it was objectionable.
That one that they argued was sustained, and they got the remedy they wanted, so that's not appealable. So you can't leverage that one objection in any way.
So here's a question from.
Thank you for. Go ahead. Sorry.
Oh, go ahead, Jeff.
No, I was going to make a random comment. I was going to thank Steve for triggering my PTSD for letting me see a copy of an Emmanuel's for the first time in 27 years, sitting on your desk there.
Right.
Oh yeah, over here. Yes.
All right. So from Let's see. From Law Self-Defense member Konsaki, question, panel, if you were on the jury, which sentence would you deem just for the convicted defendant? I spent 2 hours talking it over with my uncle. Both are in Texas, and we agreed he should get probation. Yeah, well, I don't believe he should have been convicted. So, but if given the conviction, I would go for the least sentence possible.
Yeah, I don't know.
Let's see.
I hate to be so, what would be the right word? Stoic. But to me, I mean, I deal with people getting convicted all the time that I think shouldn't be convicted. So I don't get really emotionally invested in the outcome as much as the process. I mean, it's like sometimes, like there's a lot of injustice in the world. Sometimes it's for you and sometimes it's against you. And the fact that the guy gets convicted or not, I mean, we are, and I'm just an advocate, and I am there to advocate. I'm here to play my role. And if the jury makes its call, then, you know, we keep pursuing our role doggedly. But I don't, my emotional health is not connected to a jury outcome. What it is my job is to protect the process. And that was not done here.
Right. When the state's lying to the jury about what the proper legal test is, you can't have any confidence in that conviction. And none of us should want somebody convicted on bad law.
Right.
Let's see. For Steve, this is uncharacteristic from Texas, at least in my increasingly distant experience. Obviously, this turn is scary. What do we do? I guess that must be someone with legal experience. Law Self-Defense member Kyle. JD, Law Self-Defense member JD, could the defense be under the impression they have a blanket continued objection and that's why they don't object? The judge said running objection a lot. Yeah, well, the running objections are a real problem. One is when you go to appeal, I mean, just because the trial judge allows it doesn't mean the appellate court's going to respect it.
Right.
The appellate court, you have to understand, the appellate court doesn't want to rehash every trial. They're not trial judges, they're appellate judges. So they want to address very specific questions of law from the case. And they can only do that if those questions are preserved by objection with specificity during the trial. You can say running objection all you want in the trial, but if the appellate court looks at the record and they're like, well, we don't have any idea what you were actually objecting to, there's nothing for them to deal with. And there might have been maybe 5 possible legal arguments the defense could have made why something was objectionable. The appellate courts want to know, well, which one were you making? We'll address that one, but we're not going to address all 5 when we don't even know which one you were making. They're not going to put in that kind of work.
Well, and not being a Texas lawyer, it's hard for me to comment on the specifics of that from an appellate standpoint. I'm looking at it from a Florida standpoint. And in Florida, they require contemporaneous, specific objections, or it is deemed waived. I did a little bit of Texas research, as you know, but I'm not speaking as a Texas lawyer, just as a chat commentator. And it looks to me like they have a stronger waiver set up than even Florida does. And Florida is ridiculous. I mean, I have a problem with the waiver idea because they're saying that the defense attorney was aware of it and chose not to object, when I don't think that is a fair characterization of what's going on. I think it's instead ignorance or incompetence, or maybe it's a choice, but to say that the defense attorney is waiving something is a legal fiction that the courts use to ignore injustice. Right. And I think that we're way too aggressive. And then there's a contemporaneous objection rule, which kind of cuts against, you know, you saw this judge, he's ready to light people up, man. Who are you? Get over here, go to jail, right? And so the defense attorney, when you're up there objecting, that judge is going to be lighting down fire, bringing fire on your head. And you're going to be enemy number one from the prosecutor's side, from the judge's side, from the bailiffs and everything else. And it takes a lot to stand up in front of that. Now, I've been brought in as a cleanup guy, because my board certification is actually in trial practice, in trial criminal law, not in appellate law. And so occasionally they would bring me in to what I would call discipline a judge, because the defense attorneys could not really be extra aggressive with the judge because they had to deal with him every day. So I would come in because I didn't have that problem. I was from appeals, and I would come in and be hyper aggressive on the objecting front to try to discipline the courtroom. But that is, but most defense attorneys are there. how aggressive do I get when I get shot down and shot down and shot down? And the judge is saying that objection is preserved, counselor. I'm allowing a continuing objection. Sit down. Well, you say, I don't believe that it is preserved. I want to proffer. I mean, you kind of have to go to the ends of the earth. That's a long answer. I really do have to go.
All right, Steve.
I'll see you later, guys.
Take care, buddy.
Bye-bye.
Yeah, and I will say these same prosecutors who are talking about how the sanctity of the home, if there was a challenge to a warrant that produced evidence favorable to a prosecution, there'd be no sanctity of the home argument from the prosecution. They're only arguing they're not arguing out of principle here. They're arguing out of self-interest. And you have a reasonable expectation of privacy in your home, not an absolute expectation of privacy. All right, let me hit some of these super chats. Let's see. So if you want questions or comments addressed directly from us, they need to be either in super chat form on YouTube, $5 minimum, folks. I'm seeing $2 super chats here. That doesn't cut it. $5 minimum. Or they need to be, if you're a law of self-defense member, we'll answer all your questions, no charge at all, if you put them in the member chat. And why not be a law of self-defense member? It's much less than doing super chat questions. It's less than $10 a month, folks, about 30 cents a day, and I'll answer all your questions. Just if you're in the member chat, I would encourage you to preface your question with the word question in all caps, so it kind of stands out to my attention. And you can become a law of self-defense member right now for less than $10 for the whole month, the next 30 days at lawofselfdefense.com/join. Or you can do a $5 super chat every time you want to post a question, whatever you think is most appropriate for you. Lawofselfdefense.com/join to become a Law of Self-Defense member. All right, so let's see. From Tim Pools, Yamaka Beanie on Super Chat. This defendant should have paid for Law of Self-Defense. I don't have much sympathy for a cop, but I don't think the jury was right here. Yeah, he would have had a different defense if I was involved, for sure. The Dragon's Treasure sells teas, folks. So I would encourage you to take a look at Dragon's Treasure teas. Writes, this closing is so cheesy that it's having the opposite effect on me. Yeah, I find it offensive. I kind of regret. I mean, of course, the jurors have to be kept anonymous during this process, but at least from the public. All right, they're known in court, of course. You can see them in court, but it would be great if there was a way to see their reaction to the proceedings in court, because of course the lawyers see that, and presumably they're adjusting their strategy accordingly. Jensen, $5 super chat says, "Oh, I forgot my bell. I could literally have served on this jury, and I am stubborn. Would have been a hung jury if I was there." Yeah, I'd like to think that's how it should go. Deb's June, $10 super chat says yes, but I don't know what you're saying yes to, Deb, but thank you very much for the super chat. Retired jet mechanic, $5 also says yes. I guess I must have asked a question that.
Oh, that was the, do you want to watch the draft?
Oh, the draft. Okay, right. Yeah. All right. So we went through that. Steve C, $10 super chat says, I love the poll. You'd think the entire chat hates cops and wants this guy fried. Then you poll the jury of the people, at least on YouTube, watching us, and it's the majority is for probation. Let me take a look at it now. With over 1,600 votes, 8% want 20 years, 12% want more than 10, 25% want 10 or less, and 55%, really unchanged, but still a clear majority, want probation. No time at all for this defendant. All right. Well, I'm not sure what more we have to cover. There's nothing to do now, folks, but wait for the jury to come back. But I'm not going to keep the live stream going for hours and hours while we do that. Jeff, you don't have anything to grift, man. You got to get that book going.
I do. I just got myself to grift for right now. You know, my winning and charming personality. Come over and throw super chats at me.
And that's at YouTube.
Gotta get something solid in my hand to grift.
Do you do Rumble too?
I don't. I'm probably too old to figure things out anymore.
All right. So find Jeff over at YouTube Legal Advices. I strongly recommend it. He does great work over there. And I guess I'll say goodbye for now, Jeff. If you'd like to, if we go live again, I'll send out invitations for a second stream, assuming the timing works out when the sentence comes back, and whoever can join. And of course, you're welcome as always, Jeff. Well, until then, adieu, my friend. Okay. All right, folks. So we're 2 hours in. It's hard to believe, but I'll keep my eyes out for announcement of a verdict while I'm pottering around the office doing other stuff. The moment I hear a verdict is coming in, I'll set up a second stream for announcement of the sentence, and hopefully that timing will work out. If not, I guess I'll discuss the sentence after the fact. Maybe set up a panel of folks, Steve Gosney and others, to talk about the sentencing when that happens. If I can't catch it in real time, it's not that important to catch it in real time, I guess. But we'll see what happens. Until then, just want to thank all of you for being here, all of you for your attention. And remember, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself to make sure you know the law, so you're hard to convict. Until next time, hopefully later today, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.